Good afternoon, everyone. My name is Kyle Hammonds, and I'm the manager of rights clearance at the New York Public Library. At the library, I have my hand in pretty much everything that has to do with copyright and the library and its policies. That includes rights research for rights holders within our collection. I also manage a team of digitization coordinators who are focused on facilitating digital requests through our research libraries. Also, metadata implementation. We do have a metadata management system at NYPL that has functionality for adding rights information, including copyright notices and level of access. I draft and review licenses and contracts, as well as help out with rights clearances for exhibitions and other promotional publications, among other duties. Today is part 3 in the series, and we're going to be focusing on licensing and libraries and minimizing risk. So what's on the menu today is licensing basics, basically licensing and copyright policies for libraries, some ideas about digitizing library collections, the benefits of registering your work with the US Copyright Office, and minimizing risk. Before I get started, let me give a bit of a disclaimer. Nothing you hear today should be construed as legal advice. This information is given for legal education only. It may not work for your specific situation. And if you need legal advice for your specific situation, I suggest you engage with legal counsel. Nothing the presenter myself says today should be attributed to a particular client. With that said, let's jump into it. So as library professionals, we understand, of course, the vital importance of accessing materials for our patrons. But how does that work with copyright? Now, we've talked about how libraries are able to loan materials that they own through the first sale doctrine and copying those items under exceptions for libraries under Section 108, the Digital Millennium Copyright Act, and under fair use. But what about resources that are not part of a library's physical collection? Libraries also rely on databases for indexed collections of magazines, journals, newspaper articles, abstracts, and other information. There are several advantages, of course, for subscribing to library databases. They serve as aggregates for large runs of different periodicals, runs that we might not have the physical capacity to own copies of in our libraries. And these different databases have been checked for accuracy and reliability by publishers and then licensed for distribution in an electronic format. This is important, of course, when comparing information searches to internet search engines like Google, which give a deluge of different sources that are filtered just as much by ad revenue as they are for accuracy. These databases should also be clearing copyrighted materials before posting them and including them on their subscriptions. So when you do subscribe to one under a license, there is the assurance that your institution is not violating someone's copyright. But as you probably figure, it's important to mention that these databases come at a literal price, with libraries spending a big chunk of their budgets on licensing databases. These licenses mean that the institution does not own the physical materials or the digital surrogates and are subject to the limitations and restrictions dictated by private companies, including restrictions on copying. It's also very important to keep in mind here that unless an agreement with the database company specifically states that the licensee is exempted to these restrictions based on exceptions within copyright law, they will be subject to those restrictions regardless of Section 108, first sale, fair use, and in some cases, even if that work is underlyingly in the public domain. So I can't emphasize here enough the importance of reviewing the licensing agreements for library databases when both subscribing to one or if approached by a company for the digitization of your own materials in your collections. So from a copyright perspective, it is essential that if subscribing to a database, that your institution's goals align with the uses and restrictions outlined in that license. If, for instance, there are caps for the amount of users that may access the database, you want to make sure that this fits into your number of projected users. If there are limits to copying, make sure that this won't hinder the uses of your patrons, particularly in this new normal of remote access. And definitely make sure that your institution is not responsible for indemnifying the database company for any possible infringement of copyright. Now, that's particularly important when asked or agreeing to have your own materials digitized. You may also be able to negotiate a warranty in your license that all permissions have been cleared. If a warranty or indemnification cannot be negotiated in your licenses, make sure that your institution is aware of the risk that may be involved in licensing from that database. You want to make sure that the access to the digital assets outweighs the potential risk. A helpful tip for assessing risk is researching the database itself. If you are negotiating with a large company with many library subscribers, then there is some security that the company will be taking the necessary precautions of clearing that material that's included in their database. So remember that for the most part, you will be dealing with for-profit companies that are making money off the licensing of their databases, and therefore they should be spending time and money to invest in clearing copyrighted materials for their digital collections. So an alternative to paid library databases are open educational resources, or OER. The Organization for Economic Cooperation and Development defines open educational resources as digitized materials offered freely and openly for educators, students, and self-learners to use and reuse for teaching, learning, and research. OER includes learning content, software tools to develop, use, and distribute content, and implementation resources such as open licenses. So open educational resource databases are able to do this by including content that is in the public domain or that have been released under an open license that permits no-cost access, use, adaptation, and redistribution by others with few, if any, restrictions. These licenses include something called Creative Commons licenses, which I'll talk more about later in this presentation. Now, there are many types of OER resources for users. These include course materials, modules, learning objects, textbooks, videos, tests, software, and other tools. There are also lesson plans called Massive Open Online Courses, or MOOCs, which is such a weird acronym. MOOCs are free online courses available to anyone who wants to enroll. They are user-generated and available in a wide variety of subjects. So those are a great resource despite the name. Now, although open educational resources have a very broad definition that encompasses almost any free educational tool, it's important to note that the scope for OER is primarily defined by copyright. For example, OER videos should not be made available on many popular streaming services like YouTube or Spotify, since these services include their own terms and conditions that may in fact be more limiting to access than what is underlying the content itself. So some examples of OER databases include the Free Libre Open Source Software, or FLOSS, MIT's OpenCourseWare, and Connections. So open educational resources have many advantages, including easy access for students through the internet, the openness to tailor their materials to specific lesson plans, and of course the cost. But there are some disadvantages that we should consider as well as librarians. For one, since much of the material may be openly edited and are not peer-reviewed, there is a question of the qualities of the materials that are available. Also, the fact that these resources are online means that there may be some accessibility issues for some users with limited internet access. And the fact that although these materials are presumably in the public domain or licensed, there is always the risk with an open content management system that some materials may have copyright issues that have not been considered. Some examples being protections in other countries, pre-existing licenses from their original sources, or trademark and right of publicity issues. But even with these disadvantages in mind, the fact that OER is recognized as a valuable resource internationally and is openly embraced by so many academic institutions within the US and around the world, this means that these databases will indeed grow and evolve and serve a much needed alternative to licensed databases. Like articles and databases, ebook lending also represents a growing portion of the types of materials that we are offering patrons within the digital age. Ebooks are available to libraries for lending, of course, through a few different ways: by subscription, purchase, that can be in the form of a package purchase, individual titles, the amount of users that can have a title, multi-users, or a single user license. And there's also patron or demand-driven accounts that can be serviced through libraries. Now, ebooks have become, of course, like a lot of digital resources an essential medium of lending for materials in libraries. But we need to keep in mind here that ebook licenses are generally more expensive than the buying of physical copies in bulk from publishers. And again, since they are licensed, just like the databases, there are added restrictions that are not found in physical copy lending under first sale and Section 108. And because libraries are licensing these materials, they are under the limitations outlined in their agreements with publishers and beholden to the pricing and number of digital copies that can be lent. So in that in mind, I'd like to talk a little bit about ebooks and the Senate Bill S2890B. So in January of this year, New York Governor Kathy Hochul vetoed a bill that was unanimously passed in the New York State Assembly and Senate. The bill would help to ensure that public libraries have a right to license and lend ebooks that are available to consumers in the state. New York is the second state to attempt passing this type of legislation, with Maryland being the first. The bill, in a nutshell, would require publishers who offer licenses to ebooks to the public to also offer ebooks to libraries under what is, in quotation marks, reasonable terms. The bill's summary states that the law is designed to ensure that, quote, widely accepted and effective industry practices remain in place while prohibiting harmful practices that discriminate against libraries and harm library patrons. I think it's no secret here that libraries within the United States have been complaining in some capacity for over a decade of the unsustainable and non-negotiable prices and restrictions on digital licenses by large publishing houses. 4 of the major publishing houses have changed their terms for library licensing in the last few years. The straw that perhaps broke the camel's back being when the publisher Macmillan implemented a 2-month embargo for new titles in 2019. What this meant was that the embargo set a limit of 1 ebook license per library under the standard licensing model of 2 years or 52 lendings per title for the first 8 weeks. Additional licenses could be allowed after this period. The idea here being that our patrons may choose to shell out money for an ebook on their own when faced with the daunting numbers of e-reserves ahead of them for that single copy in that first few weeks. This led librarians and advocacy groups to take their grievances to the state level. Now, bear in mind that the reasonable price proposed by the bill had not been finalized, but at the very least, the bill would offer some standardization of how libraries are priced for ebook licenses, which despite some publishers' complaints, we are still some of their biggest customers. But for the publishers, bills like these are seen as a violation of copyright law in that they are attempts at standardizing pricing, which is arguably a violation of a copyright owner's exclusive rights to their work. And those exclusive rights include the market value that they propose they are worth. Now, even though the New York bill is on kind of a temporary hiatus as it goes through edits to be reapproved by the governor, the Maryland bill actually did pass at the beginning of 2022. So we will have an interesting test case to see if this helps or hinders librarians and authors going forward. Now let's talk a bit about digitization of library collections and specifically what sorts of collection materials are safe or sort of safe to go online. Digitization is an expensive endeavor, and it is becoming more and more essential, on the other hand, for preservation and access to collection materials. Now, we spoke in part 2 about how Section 108 and the Digital Millennium Copyright Act does allow the digitization of collection materials for preservation or replacement of collection materials. But there isn't a lot of there in terms of how we can access as libraries those digital assets. Now, collection items determined to be in the public domain can be included on a website or database without worry. These include, a little review here, these include currently works published in the US before 1927, unpublished works in which the copyright has expired, again, that's life of the author, plus 70 years for unpublished materials, works created by a branch of the US federal government, and works published in the US between 1927 and 1978 that fail to adhere to proper copyright formalities. But what about in copyright materials? Now, licensing permissions with a rights holder is, of course, a great means of getting in-copyright materials available online. Many rights holders, particularly estates, have a representative like a lawyer or agency that are there to license that author's work. An example would be, say, the Artists' Rights Society, which represents many visual artists or their estates. There are several types of licensing that a rights holder may issue. Requirements may include a licensing fee, limitations on the duration that an image can go online, limitations on the types of online uses, such as limiting social media or advertising use, and limitations on how the image may be presented. Sometimes they might have restrictions on cropping or requirements for approval to see the page layout or colorization of the image before it's posted. Now, the New York Public Library has its own set of non-exclusive licenses that we often offer to rights holders, which grants a level of use for an institution, but also allows the rights holder to grant permission to other individuals or institutions as well. And these uses can be modified to be quite broad or limited to, say, non-commercial uses, for example. And for digitization, there is also fair use. Though, again, from what we discussed in part 2 of the presentations, fair use does carry a lot of responsibility in making an argument for your use as well as risk assessment. And the recent resolutions to cases like Authors Guild v. Google does show a broadening of the court's view of transformative use and online digital collections. However, as I also pointed out in part 2, although case law sets some precedent for how we can use creative content, fair use is still subjective to one's particular case. And the next case seen by the court may change that precedent. So there is a bit of risk analysis that needs to go with any fair use claim. Now, one example of works that cultural institutions are taking much more of a stance of making accessible digitally are what we call orphan works. I mentioned this earlier in the presentation, but to review, orphan works are works that are still technically in copyright, but where a rights holder is unable to be contacted for licensing. This could be because there is no attribution for the work, the author may not be locatable, or there is no known active estate or living heir. Now, cultural institutions do have a very important responsibility to make our collections accessible in whatever form our patrons need to access information. But how do libraries and museums take the plunge and exhibit these important works when faced with the very real possibility that if a rights holder comes forward and files suit, that institution may be liable? And how do we, as scholars, researchers, and archivists, protect the integrity and intellectual property rights of these creators? What we need is somehow to find a balance between these two dichotomies, between access and protecting rights holders' copyright. So how do we do this? One example I'd like to give everyone is known as implementation of best practices by memory organizations. This was a proposal that was outlined in 2014 under the joint publication titled Statement of Best Practices in Fair Use of Collecting Orphan Works, which was comprised of contributions by several law schools and scholars and had funding by the Alfred P. Sloan Foundation. Now, keep in mind that this is not a federally recognized guideline for fair use. Regardless of that, though, it does offer what I consider personally to be some good justifications for increasing access to orphan materials that would benefit our patrons and, in ways, even the rights holders themselves. So let's dig into that a little bit. The report suggests that memory institutions, such as libraries and museums, can digitize and make limited use of orphan materials under fair use, which offer guidelines for the use of in-copyright material, again, under the 4 factors, which for review are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion taken, and the effect of the use on the potential market. Now, memory institutions also have exceptions allowed to them under Section 108 and Section 504(c)(2). For 108, we are allowed the duplication of collection materials to patrons for research purposes. Currently, this exception only applies to libraries and archives, but may see expansion to museums with future revisions to that section. 504(c)(2), quote, shields nonprofit libraries and archives from costly statutory damages awarded them when they make a good faith assertion of fair use, even ultimately if that is a correct one. So that's another exception given to copyright law for libraries and cultural institutions. With all that said, we've also seen recent favor by the courts for digitization under fair use in both the Google Books and HathiTrust cases, which favored conscientious fair users. This also showed that new trends in the court that the viewing of transformative works under fair use is more and more acceptable when the purpose and display serve to repurpose and recontextualize that copyrighted material in order to present it to new audiences, thereby facilitating new information discovery. Now, arguably, when considering orphan works, the cost-benefit dichotomy, which drives fair use, seems to be fairly clear-cut. So let me go over that in a little more details. The factors that you want to consider when digitizing orphan works is, does the use transform the material taken from the copyrighted work by using it for a broadly beneficial purpose that's different from the original? Or did it just repeat the work for the same intent and value as the original, in fact, just merely substituting it? Was the material taken appropriately in kind and amount, considering the nature of the copyrighted work and the amount used? Again, transformative use of orphan material can also be furthered through the context in which that material is showcased. For example, descriptions of the material and its historical context written in, like a blog post or informational resources or something like that, or even creating new platforms that would give access to these works, which was the argument that Google made with the Google Books case. And in many cases, the digitization of orphan works, it has been found that the use poses almost no risk of market harm. If owners cannot be located, there is still a chance that there is a current functioning market for those works. Further, the fact that those works remain unexploited is a strong signal that their potential economic value in any future developed market would in fact be small. So considering the percentage of works created, relatively few works are continuously commercially published, and even fewer of those have any long-term commercial value and often go out of publication quickly. So when considering the market harm for unpublished materials, digitization projects in fact offer a level of exposure to these materials that may even open up the possibility of commercial viability and further down the road publication, or for published materials, bringing those back into print. But with that said, there needs to be some record of due diligence for your institution before making digital orphan materials available online. And one advantage to this is that as more institutions consider and do this, we can actually communicate due diligence between institutions. Something that comes up a lot for my department is that other institutions will reach out asking for what information we might have on a rights holder. And we ask the same of other institutions. Sometimes we get new information or a contact that makes something we considered an orphan suddenly find its home. So for NYPL, the rationale for a limited non-commercial display of orphan material includes a number of factors, and I'll go over those briefly here. We limit the access to these digital images to just New York Public Library produced websites, primarily our digital collections website, which we consider an extension of our physical research platforms. NYPL does not represent any of the rights of the orphan materials featured, and we make sure to state that in the rights statements on those pages. We also have the ability to easily take down those materials if claimed by a copyright holder, and the option of negotiating a license or other type of agreement with the rights holder if they were to come forward. So the idea of established best practices for digitization of orphan works may also help specifically underrepresented groups, as long as we have some due diligence information that is recorded and can be passed along as the material is utilized to the public. I can't emphasize that need to give a good due diligence. So what I'd like to do here is to give an example of an orphan work that the New York Public Library has given digital access to. And what these are the green books. I'm not sure if you're familiar with them, but they're just an incredible piece of historical ephemera that I would highly encourage to go in digital collections and check out. What they are is from the 1930s to the 1960s, the Green Books were annually published travel guides that listed food and lodging that was not discriminatory to African-American travelers during the Jim Crow era. As the introduction of the 1949 issue states, quote, "With the introduction of this travel guide in 1936, it has been our idea to give the traveler information that will keep them from running into difficulties, embarrassments, and to make their trips more enjoyable." These books were edited and published by Victor H. Green and Company, and the New York Public Library has one of the only complete runs of the publication, and we've digitized them for preservation and to present them online. So most of the issues were actually in the public domain due to their publication year or their lack of following copyrighted formalities. So we now have those to be with the high-res files available to our patrons. But I would like to point out this 1966-67 issue, which indeed is actually in copyright, but an orphan. So why is this work in copyright and an orphan? This issue, the 1966-67, includes a proper copyright notice. Again, most of the issues were published before 1964 and lacked notice, registration, and renewal. However, this issue, because of the inclusion of a proper notice, was automatically registered with the Copyright Office due to changes in copyright law during the 1976 Act. So, given that this issue would be the only one in the entire series that would not be available to go online, we identify this as an important missing piece of the full collection for our researchers and felt it would be of great value to include it on digital collections. So we did our research to identify it as an orphan. I mean, granted, if there was a rights holder to come forward, we would go the licensing route, but we could not find one. So here's an example of some of that due diligence research. We know that the work was edited by Victor Green and was published by Victor H. Green and Company. Victor Green was born in 1893 and is deceased. We found in a 1940 census that his wife, Alma D., father-in-law, William J. Duke, and brother-in-law, Robert E. Duke, were all at the same address, but there were no sign of children for him or his brother-in-law. And the 1920 and 1930 census only showed him and his wife to be at that residence. Now, Victor did have a brother, William H. Jr., who married and had 3 sons and 3 daughters, some of whom also had children. However, no record had been found to date for these heirs, and it is presumed that William, his brother, is deceased. So based on our due diligence search for a copyright holder and an assessment of risk, NYPL decided to include this issue of the Green Book, which made a complete collection online and available for our researchers. But now bear in mind that the specific issue includes a statement on our digital collections page that explains that there may still be an existing rights holder for this work, and we do limit the access by not allowing a full high-res download for the issue. And we've also taken the precaution that if a rights holder were to come forward, we could take down the images quickly and would try to secure a license with that rights holder. I'd like to switch gears a little bit to the left, since we're talking about orphan works and the benefits of having some kind of breadcrumbs leading to a copyright holder, to talk about the benefits of registering your own work. Now, as we've spoken about in previous presentations, under US law, currently anything that is within the scope of protection of copyright law is granted copyright protection at the moment of fixation. It doesn't have to be published, it can be unpublished, but it needs to be in a fixed medium. Again, registration is not required or the inclusion of a copyright notice. However, registration does confer some benefits for the copyright owner who registers. For one, it's just simply the benefit of leaving your mark. It gives a sense and evidence of ownership of that work. And those copies, too, under Library of Congress's current policies, are preserved in the Library of Congress. So when you register your work with the Copyright Office, you are required to give 2 copies. And say you actually need to go to court to protect your work against an infringement, timely registration opens up the possibility of statutory damages instead of regular damages, which tend to be much less. Registration also preserves the possibility that you'll get your attorney's fees paid by the other side if you actually win as the plaintiff in your case. Registration is typically pretty simple. I'm giving an example here of their online page, which, yeah, it's a little esoteric, but it still gets the job done. It's only $35 for a single application, $55 for multiple, and $85 if you wish to file on paper. The 2-copy rule has actually been expanded. So if your work is, say, a born digital item, you can actually submit JPEGs of your work, like photographs or things like that, rather than required to have a physical copy of the work. Let's talk about minimizing risk. I'm always debating if I should save this for last, and it usually does. And so I don't mean to put fear in everyone's hearts at the end of a 3-part series, but we do have to talk about it a little bit. So, again, we've been talking at length about what is copyright and how it serves to protect creative works. But we also need to ask, why should we care about copyright? Well, the maximum statutory damages can be as high as $150,000 per work infringed. That's under US law. So, hypothetically, if there are 10 works that are found by the courts to be infringing, then maximum damages could be as high as $1.5 million. Now, depending on which side you're on, maximum statutory damages are either the best case or worst case scenario you can face. But just the cost of litigating copyright cases can range from over $300,000 to up to $2 million per side just to argue the case in a proper court of law. So let's talk a little bit about how you can use work by other rights holders for your own projects, minimizing that possible doomsday scenario. First off is licensing. Clear the permissions to use material with the rights holder, either directly or indirectly. So examples are for images. There are stock houses like Getty, Shutterstock, or Alamy. Many of these will offer a license that grants you not only the image, but the permission to use it. If you're dealing with text, there's the Copyright Clearance Center, Society of Authors, or you have the ability to go directly to the estates or representatives for those authors and clear directly. Now, you want to make sure when seeking licensings to make sure that you're working with a rights holder, a representative for that rights holder, or that that person you're in contact with has the ability to sublicense on behalf of the rights holder. That's particularly important in cases of joint or collective works. Also, consider the public domain. Pre-1927 published works or unpublished works in which the author died over 70 years ago can be used. And that does involve sometimes some research. We've gone over some of the ins and outs of how to research copyright status, but that could be a great way to investigate. And I will point out that some of these image licensing companies do post public domain images and charge you a fee and a license, although if you do the research and look for other sources, you can verify that it is indeed in the public domain. Also, fair use. Again, under the 4 factors, you do have some grounds to use material without seeking permission. Just to hone this into everyone's head, I'll give a few examples. Is the work being used for reporting? Are you using that essentially to describe events for news or journalism? Is it transformative? Are you creating something new from the original that expounds upon the source material or critiques it? The nature of the work, say for reporting factual events, or is it essential in describing events for journalism and news? How much you're using, the amount used. What is the least amount of text or footage or what have you that you can use that will articulate what are you trying to get across, and considerations of the market value. Does your use affect the market of that original work? Will it contribute to decreasing the market value of the original, or do they address separate markets altogether, or may actually help to bring about sales for the original, going back to the Two Live Crew Roy Orbison case that we talked to in part 2. And going back to something I mentioned earlier, Creative Commons, or CC. These are a set of copyright licenses that allow different levels of use of materials under specific restrictions. Some important licensing examples under Creative Commons are what we call CC0. That's a case in which the rights holder relinquishes all right to their work. So it is basically in the public domain because this license relinquishes all rights to that particular item. There's also CC BY, which means that you are free to use the material without restriction as long as the rights holder is properly attributed. CC BY ND, that means you are free to use with proper attribution, but you're limited to only sharing the material with others in the same form that the original work is. So be the equivalent of if it's an image on the web, you could use it for other web pages, but not necessarily to use it on a mug or publishing it in a book. And there's also CC BY NC, which means you're free to use with proper attribution, but only for non-commercial purposes. And this slide has what are called tags. So most CC materials should include one of these tags, which gives you the level or the acronym for what level of access you have under that license. Really, the way to do it properly when applying a CC license is to put this tag that includes a link to Creative Commons' website so you can get more direct information about the level of access you have to that material. So in terms of damages for infringement of copyright, going back to the risk part, I'd like to conclude by talking a bit about a very recent piece of legislation that may, in theory, make copyright cases a bit easier to resolve. I'm talking here about the Copyright Alternative in Small Claims Enforcement Act of 2020, also known as the CASE Act. This is a law that was passed by Congress in 2019. Normally, copyright cases are heard within the federal or state courts, which of course can be extremely expensive. Now, the CASE Act establishes a small claims tribunal system within the US Copyright Office for copyright owners seeking damages that are much more limited than the fees I was talking about before. So these would be up to $15,000 for a single infringement or $30,000 for a claim with multiple infringements. There's a 3-person claims board that substitutes the need for a judge, and you can hear copyright infringement claims filed by the copyright holder, declarations of non-infringement cases brought on by users, and misrepresentation claims under the Digital Millennium Copyright Act. So this 3-person tribunal really covers a lot of ground in what types of cases they hear. The board, as they want to be called, is also empowered to determine fair use in cases. Parties are not required to have a lawyer, so that saves a lot of money, or even be present for their case being heard. Now, creatives still have the option to forego the CASE Act and the tribunal and have their cases still heard in federal court, or they can have it settled out of court. Similarly, the accused infringer has the option to opt out of having the case heard by the board. So this may all sound streamlined and great, but there are a number of parties who are critical of some elements within the act. The main criticism is the opt-out option. Although this may sound voluntary, it does create a plausible possibility that copyright trolls, which are different parties that make a point of searching the internet or other sources to find copyright infringement or what they believe they can get some quick cash through an out of settlement and issuing cease and desist or taking it to court. So with the CASE Act, if you don't properly opt out, these trolls or other people looking to find multiple infringements can give you a whole bunch of these cases, and you have to actually opt out of each individual one. You need to bear in mind that if you do not opt out of the case within 60 days, then the tribunal will hear that case and you may be on the hook if an infringement is found to pay that $15,000. Also, there's an ambiguity of how the tribunal plans to judge different cases, and there's the lack of participation or a need for a lawyer, which on one hand is good, actually might affect, how internet users may perceive having to go in front of the tribunal, and that may scare them off from things they would actually have grounds for to use under fair use. Now, earlier versions of the law required that an accused infringer would need to opt out of each individual case made, but there have been recent revisions now given to academic libraries and archives with an exception to fully opt out of all cases brought forward under the Act. And even more recently, this exception was further expanded to include library employees, not just the institutions they work for. And that's particularly important since we as librarians are often the ones creating content for our collections, such as blogs and guides that may be targets for trolls to slap infringement cases on. It sounds like I'm giving a lot of shade to the CASE Act with these scenarios, but I do want to express that the advantages of having a small claims system will definitely help out in the long term. I'm just hoping that as we start hearing of these tribunal cases being heard, that further revisions will be made to the Act and we can really get it to work efficiently for all users. So again, I want to just thank everyone for participating, and I hope everyone who's tuned in has gotten something out of it. So thanks, everyone.